Hello, welcome to Workplace Wake Up. I'm Jen Shaw. Every week, I spend about 15 minutes covering key legal developments, introducing you to interesting guests, and providing some entertainment to start your workday. I hope you enjoyed this week's episode. We are going to be talking about a recent California Supreme Court case called the Naranjo versus Spectrum Security Services, Inc. matter. All right? And in this case, which is very important, the Supreme Court actually issued a really pro-employer decision. Now, one of the things you have to understand about this case is it has been up and down to the California Supreme Court, the courts of appeal, back down to the trial court. And the whole issue here was penalties under Labor Code Section 226. Now, as many of you probably remember, Labor Code Section 226 dictates the information that must be included on itemized wage statements. These are the tear-off portions of the checks, right? The ones that talk about how many hours you worked and how much vacation you used and what your California Healthy Workplaces, Healthy Families Act sick leave balance is. One of the things that has been really difficult for California employers about PAGA, the Private Attorney General's Act, which we've talked about several times here on the podcast, are the penalties available under Labor Code Section 226. Generally, if you've got any errors, any problem on your wage statement, you are going to be subject to a 226 penalty. And one of the things that has always come up for employers is, wait a minute, I didn't know I was doing it wrong. I didn't know the payroll company got the name of our company wrong. I didn't know that the overtime calculation wasn't shown properly. I just didn't know. I didn't do anything on purpose. So back in 2022, the California Supreme Court said, okay, extra pay for missed breaks, meal and rest period breaks, which is penalty pay under Labor Code Section 226.7, that premium pay is wages, and therefore it's got to be reported on the itemized wage statement. So that's under Labor Code Section 226. And then and I know this is sort of a technical podcast here today, but under Labor Code Section 203 that you owe waiting time penalties if you don't pay a departing employee their final wages in the right time period. So if you fire them, you owe them their wages immediately, right? You can't say, I'll send you your check in 3 days. And if they quit with at least 72 hours notice, you've got to have the check on that last day. If they don't give you 72 hours notice, then you've got to have the check within 72 hours. So those are called waiting time penalties. Okay, those are Labor Code Section 203 penalties. So in that case back in 2022, as I said, the California Supreme Court held that those premiums under Section 226.7 for missed rest and meal periods or short rest and meal periods, etc., are wages, and therefore they have to be paid within the timeline set by Labor Code Section 203. So immediately on termination, immediately if an employee gives you 72 hours notice, and within 72 hours if they don't. The Supreme Court sent back the case to the California Court of Appeal to wage statement penalties under Labor Code Section 226. In other words, were they entitled to a remedy because the wage statement wasn't accurate? Now, mind you, they were paid appropriately, okay? The question is, were they entitled to those penalties? And what the court said, the Court of Appeal said, listen, they're not going to be liable for those 203 penalties, the waiting time penalties, because they never paid the missed rest and meal period penalties, because the failure was not willful, okay? So they said, look, the employer here, Spectrum, they had a good faith basis for believing that they were not liable. They thought they were doing everything right. And they said, look, when you look at Labor Code Section 203, which says you willfully failed to pay final wages, and Section 226, which talks about knowing and intentional, they're basically identical in substance. So if an employer has a good faith that they've done everything right, then they should not have to pay those penalties. So the California Supreme Court unanimously agreed with the Court of Appeal decision. They said, okay, if an employer believes reasonably and in good faith that they've done what they're supposed to do, the fact that it provided a wage statement that had an error on it doesn't mean anybody gets 226 penalties or 203 penalties for former employees. All right. So what does this mean? Well, under Labor Code Section 226E, okay, the violation of that section is penalized at up to $4,000 per employee. And in addition, the employee's costs and reasonable attorney's fees. So when we talk about PAGA claims, right, you can have a bunch of employees who are going to be subject to that $4,000 a piece wage statement penalty, all right? With the new Supreme Court decision, okay, the court said, listen, if there's good faith defense, you don't owe the penalty. That is going to significantly limit employers' potential liability. And that's important because if you think about this idea of PAGA cases, plaintiffs will often claim, okay, there's a wage statement violation. That means I wasn't paid my wages properly. That means I'm entitled to Labor Code Section 203 penalties, waiting time penalties, because I left and I wasn't paid the correct amount. That's $8,000 per employee. So now we can say, okay, we were acting in good faith. So how do we deal with this issue? Well, the Supreme Court's analysis in the Naranjo decision does offer some hope for employers, okay? And under PAGA, remember, aggrieved employees can file a civil action where they're essentially representing the state's labor enforcement agencies, right? Like the Division of Labor Standards Enforcement. And they can allege a number of wage and hour violations. And then there are penalties for those that they can recover, generally about $100 per employee per pay period. And remember that even something minor can be a violation of PAGA. It can be what they call a technical violation. So anyway, the problem with PAGA cases, of course, is all of these penalties start adding up, and then you have a very significant liability on behalf of the employer. So what's going on here is that the court just decided in early May, if there is evidence that the employer acted in good faith, then they're not going to have to be responsible for these penalties, not 226. And therefore, if it's not 226, it's not 203. This is good news, but it doesn't mean you shouldn't be making sure that you're complying with the rest break and meal period requirements. We're going to do a little wage hour compliance session in a couple of weeks, so you guys can keep in mind what all the basic rules are here. It's important to know that with the Naranjo decision, we do have some help, right? Employers are going to have a little bit of potential cover if they do something wrong. And I mean, if they accidentally do something wrong, right? If they can show, look, we hired this giant multinational payroll company and we assumed they were doing everything correctly and they didn't. So we were acting in good faith. We didn't hire Joe's payroll around the corner. We hired a big company to do this and we had a right to rely on them. So there's a lot going on here. One of the things I want you to understand about this decision is just like the U.S. Supreme Court, the California Supreme Court does make decisions that some people disagree with, right? And they'll look at the rationale of the decision and they'll say, well, there was some validity to the rationale or there wasn't. They have a tough job, these Supreme Court justices, whether we talk about California or on a federal level. And as an employer community, we want to make sure we understand the underpinnings of these decisions so we can really begin to use them to drive our own internal processes and practices. So these decisions are intellectually interesting, but they're only useful if you actually use them, if you actually do something where you can think about how do I apply the rules in this decision to what I'm doing on a daily basis, to how my business operates. So, for example, in the Naranjo decision, you now know that you may have a defense in litigation. That's great, but we don't ever want to get to litigation, right? So what steps are we going to take to make sure that your rest breaks and meal periods are compliant, that you're documenting them? We had such an important case come down years ago, the Brinker decision, from the California Supreme Court about these issues with rest breaks and meal periods and penalties and premiums. And employers still get this wrong. They don't understand that under most of the wage orders, the first meal period has to begin before the end of the 5th hour at work. That means 4 hours and 59 minutes into the shift, not 5 hours and 59 minutes, right? I have to count on my fingers, right? Let's say they come to work at 8 o'clock. 8 to 9 is hour 1, 9 to 10 is hour 2, 10 to 11 is hour 3, 11 to 12 is hour 4, 12 to 1 is hour 5. So they better start the meal period before the end of the 5th hour at 12:59 p.m., not 1:59 p.m. Okay, so there's a lot that comes behind these issues. And when you're talking about compliance related opportunities for your organization, number one, you've got to make sure you know the right law, right? And then number two, you have to think about, okay, what are we trying to do here as an organization? We obviously don't want to be writing big checks to plaintiffs' lawyers. We don't want to be losing cases in court. We don't want to be spending a lot of money on defense attorney fees. So it's definitely worth it to put the money in the preventive side of things, right? This is what our whole practice is. We talk about it, advice and policies and procedures and investigations and training. We try to keep everyone out of trouble. And that's really the philosophy that a good HR professional has as well. You can read a decision like the Naranjo case and you can understand the rationale of the court, but what you've got to do is draw the connection between the rationale that the court provided and what you're doing in your organization on a daily basis. That is what you need. So somebody said to me today on a call, who's a lawyer, by the way, but not an employment lawyer, I'm giving them advice about their policies and practices in their law firm. And she said, well, we could just fire the HR person. I mean, they're a dime a dozen, right? I said, wow, I don't think you've worked with HR. Because actually, to find a solid human resources professional who understands the law and has the chops to be able to help you make these kinds of decisions, it ain't easy. And I think HR is a great field for people to be going into right now. Learn the ropes, work with an organization where you can have a mentor, understand what your purpose is. Your purpose is to not only keep the employer out of trouble, but to do the right thing, to help with recruiting, to help with retention. What do we do to convince people that this is where they need to be and this is where they want to be? That's really what it comes down to. So when we talk about this idea of compliance and wage hour audits, where you figure out, and we'll talk about these more in a few weeks, but where you really figure out, okay, what's going right and what's not going so right, and how are we going to fix these situations? All of that is part of the rubric of a compliance program, HR development. All of these things come into play. So I wanted to talk to you about the Naranjo decision because it is a really important case. If any of you are getting ready to go to mediation, you want to make sure that your lawyers are going to use this case because it's going to be very helpful for you. But the big picture, the long game is, okay, what are we going to do going forward? How are we going to make sure that we use not only the decision, but the basic concepts in wage hour law to keep us out of trouble? How do we make sure that people are being paid for every minute they work? All of those issues are critical to us understanding our role as HR professionals and how we can be value added to the organization, because that's really what it's all about, right? The reason I love my job is that I feel like I make a difference. I feel like I get to help people make decisions and get them going in the right direction and help them evaluate options. I love what I do. I don't talk to a lot of lawyers who love what they do. But employment law makes it easy because it's about people. It's about problem solving. It's about really being part of a team, which I love. It's why I love the law firm. It's why I love working with everyone I work with here. Is we're a team to provide the employer the best advice or the best investigation or the best training or the best defense to a claim that we possibly can. So I want you to realize the value you bring to your organization as an HR professional and go out there and get it done. Everyone, thanks so much for joining us today. I cannot believe we're already in June. It's so crazy. So I hope you guys are having a wonderful summer so far, and I'll talk to you next week. Thanks so much. Workplace Wake Up, including our guests and hosts, do not provide legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction. If you enjoyed this episode and would like to spread the word, please share it with others, post about it on social media, and/or rate and review it. You can also follow us on LinkedIn, Twitter, and Facebook, and email us at info@shawlawgroup.com.